Welcome, I'm Russell Alexander. We help families going through separation and divorce. I've been a lawyer with the team here for over 20 years. Let's get into today's topic. How do courts choose which school a child should attend? It's hard to believe that summer's almost halfway over and that soon kids will be returning to school. With the COVID-19 pandemic not yet quite under control, the dominant issue in minds of most separated and divorced parents will be whether their children will be returning to in-person classrooms or learning remotely, or perhaps some blend of the two. However, newly separated parents may still be in a dispute over which schools the child will attend in the first place come the fall semester. It's therefore important to take a step back and reflect on more broadly on the laws and principles the Ontario court will consider when asked to decide which school a child should attend. In a recent case, each parent asked for a temporary order, placing their only child in different schools. After noting that the child's best interests were not merely paramount, but the only consideration the judge drew from the prior ruling in Thomas, where the court had compiled a list of all the leading cases and provided a thorough summary of the governing elements. From an overview perspective, the court noted the following points. The cases are very fact-driven. The courts do not pronounce on what is best for all children in a general sense, but rather decides what is the best interest of the child for the court. From the standpoint of authority to decide, the court specifically empowered under the Children's Law Reform Act to determine any matter incidental to custody rights. The issue of a child's enrollment in school program falls into this category. Custodial parents should generally be entrusted with making the decision to which school the children should attend. When a sole custodial parent has always acted in the best interest of the child, there should be no reason to doubt that this parent will act in the best interest of the child when deciding on school. Next, the court addressed how each of the parents' plans for the child's education are scrutinized and assessed. It stated, it is implicit that the parent's plan for a child's education and his or her capacity and commitment to carry out the plan are important elements affecting a child's best interests. In developing the child's educational plan, the unique needs, circumstances, aptitudes, and attributes of the child must be taken into account. When considering school placement, one factor to be considered is the ability of the parent to assist the child with homework, and the degree to which the parent can participate in the child's educational program. The parents must be placed on the interests of the child and not on the interests of the parents. That's the focus. If you're enjoying this video and find it helpful, you can give us a thumbs up or leave a comment below. There are also a number of more esoteric factors to consider, namely the importance of a school placement or educational program may include considering whether it will promote and maintain the child's cultural and linguistic heritage. Third-party ranking systems, such as the Fraser School rankings, should not factor into the court's decision. This is because those systems of ranking do not take into consideration the best interests of the particular child in a family context. Any problems with the proposed schools can also be considered by the court. Finally, the court noted that there are some fact-specific details and other evidence that it may examine, including concerns around the child's transferring from school to school. The court said a decision as to the choice of school should be made on its own merits. It is based in part on the resources that each school offers in relation to the child's needs. It's not to be based on the school's proximity to the residence of one parent or the other, or the convenience that his or her attendance at the nearest school would entail. Factors that may be taken into account by the court in determining the best interests of the child include assessing any impact on the stability of the child. This in turn may include examining whether there is any prospect of one of the parties moving in the near future where the child was born and raised, and whether a move will mean the child's care providers or other unsettling features will be affected. The court would also look at decisions that the parents make with respect to schooling prior to separation or at the time of the separation. If an aspect of a child's life, such as school placement, is to be disrupted by an order of the court, there must be good reason to do so. Before a court will order a child to transfer schools, there must be convincing evidence that the change of the schools is in the best interests of the child. To learn more about this case, you can read the full article linked in the description below. Please leave your thoughts and comments below. If you liked this video and found it helpful, give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video.